So what is a power of attorney? There are two very essential POAs, as they are known, utilized in a living trust. In this video, we will give a brief explanation of both forms of powers of attorney that are basic ingredients to estate planning and are always included in living trusts. Each serves a very distinct purpose, and each is a very significant piece of the trust puzzle. The first one is a financial power of attorney, essentially powers over financial matters. No one wants to think about bad things happening. Unfortunately, bad things do happen, and it's a part of life, which is why it is a good reason to be prepared. Actually, everyone over the age of 18 should have a durable power of attorney over finances. The word durable simply means it's in place for as long as it's needed. Having one means that you're able to name someone to take care of finances in the event you're not able to. For example, an 18-year-old incapacitated in a car accident with a POA can allow a parent, brother, or sister to handle their financial affairs until the crisis is over. You never know what can happen in the future. Suppose you don't have a power of attorney in place. What happens then? Your family may have to go to court to obtain permission to manage your financial affairs. This process can take time and is costly, not to mention the stress to the family. Involving a third party in your private affairs is something that should be avoided at all costs. If you're married with a joint account, it's still a good idea to have a POA. Suppose, for example, both you and your spouse are in an accident and unable to care for your financial matters. Having someone authorized to step in can prove to be very helpful. A backup plan in the case as this is both advisable and can prove to be entirely necessary. One of the unique features of the document is that it is a springing, durable power of attorney. What this means is that it only comes into effect when and if it's needed. The term durable again means that it lasts until you're able to start making decisions for yourself again. At that point, the POA goes away and you take back control. This way, your financial matters can be handled in a timely fashion without missing a beat. Bills are paid without jeopardizing your credit rating, and your reputation with your creditors remains in good order. Your appointed agent has no authority unless you are incapacitated, and only then does this role as your financial agent come into effect. Hopefully, you will never need this document, but if something does happen, you know that the person that you appointed will take care of your financial matters on your behalf until you are once again able to take control. A financial power of attorney can provide for the handling of your financial affairs in a timely and seamless fashion. Next is the healthcare power of attorney or durable power of attorney over healthcare. For those bad things that can happen in life, you also need a durable power of attorney regarding your health. As mentioned before, and like the financial power of attorney, everyone over the age of 18 should have a durable healthcare power of attorney. This legal document enables someone that you name to make important decisions about your healthcare in the event that you are unable to. It gives that person called your agent instructions regarding the kind of medical treatment that you want and authorizes that person to carry out those wishes. So why is having this document so important? Suppose you didn't have one and something happened. You never want your life to be in a position where decisions have to be made and no one is legally prepared to do it. Can you imagine the anxiety that such a situation can create? It could mean that your nearest living relative is called upon to do it, and it could even mean a court-appointed guardian would step in to make decisions on your behalf. All of this can take time. Valuable time lost as family members and caregivers try to figure out what to do. So even in the event of that remote possibility, why even allow such a situation like this to develop? Then there's the potential for division amongst family members. Arguments can erupt when family members can't agree or a court order is needed. All of this is time-consuming, stressful, and costly. And how about if you are married? Your spouse would be able to make decisions for you, right? Well, most likely yes, but having a backup plan just in case you and your spouse become incapacitated is the wise thing to do. And besides, it may turn out to be too emotional for your spouse. Then what? Having a plan in place to cover these possibilities is always advisable. HIPAA, or the Health Insurance Portability and Accountability Act, has to do with patient healthcare information being kept private in the absence of patient consent or knowledge. The Healthcare POA has a HIPAA waiver that grants your healthcare agent the right to be informed by your attending healthcare provider as to the status of your medical condition. Once you recover and are able to make decisions for yourself, the legal right that you have given to your healthcare agent stops. You may wonder if you really need this document if you have a living will and an advance directives document. The short answer is yes, you actually need both. The healthcare power of attorney is for decisions to be made prior to end-of-life scenarios, which is what the living will and advanced medical directives are in place for. As stated, the living will and advance directives cover important end-of-life or near end-of-life decisions. Having one is critical if your healthcare agent can't be reached or if your healthcare agent can't make difficult decisions. Hopefully, you will never need a durable power of attorney for either healthcare or financial matters. But in the event that you do, you will be prepared. The peace of mind can be priceless should that day ever come. Having these documents in place means that your loved ones are spared the additional stress and anxiety that come with the process of involving the courts regarding decisions that need to be made on your behalf. This is why we are America's best choice for estate planning. You have 24/7 access to all of your documents. You can update them, print them, and even email them. So go to our website, moneysense.solutions, click on Our Services, and scroll down to the bottom to Living Trust Made Easy to find brochures, frequently asked questions, as well as an opportunity for a free 10-day trial.